Hello, good morning, and welcome everybody to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. It's been a long week. It's been a very, very busy week, but I have been looking forward to this, and this is going to be a really excellent Sunday Fun Day. So, hello to Alicia K. Mayo, and to Shy Gal, and to Hazel, and to Lily Polly. Thank you guys so much for showing up. And Akasha, I know I messed that up. Akasha, thank you guys so much for being here. Marie Jubenville, thank you guys for carving out a little bit of time on a Sunday to be here. My name is Joshua Ritter. I am a former prosecutor with the LA District Attorney's Office. I was there for 10 years. I left the office, went into private practice. I'm a criminal defense attorney now. I've been doing that for nearly as long. This is Courtroom Confidential. Our mission on this channel is to try our best to present to you both sides of the courtroom, and we hope that we do that. And this, the show that you've showed up for today, is Sunday Fun Day, where we take questions that you sent us throughout the week, we play them live, and we answer them live. So thank you guys for being here. Please take a moment to hit those subscribe buttons. Somebody put in the left a message the other day saying, go ahead and subscribe. It's free. And I didn't think about it that way. Yeah, it's a free thing. Just go ahead and subscribe. You're not going to receive any spam mail, and you're going to help the channel. You're going to help us support us and help us to grow. So today's a good one. I've listened to these messages. You guys absolutely came through. We had a ton of messages. Again, we're in that sticky situation where we're just not going to have time to get to all of them. But I thank you guys for sending them. I tried to answer at least every subject matter that we possibly could have touched on. And you guys are really going to enjoy, as always, the wide range of topics that we're going to discuss for today. So thank you all for being here. We've got some surprises for you. Let's get jumping right into it, huh? Let's not waste any time with our first question of the day. And I know I've already got it messed up because I don't have it on the thing, Kaylin. So here we go. All right, here we go.
Hello, this is Misbehaving from Wales. So I've been watching the live trial of Karen Reid with Emily D. Baker, and also following that with watching other lawyers and police officers and CSI techs lose their minds over both the testimony on cross and the lack of investigation by Trooper Bukhenik. I was wondering what your reaction was, and would you have laughed them out of your office if they'd thought to bring you the investigation? Thanks a lot. Bye.
Misbehaving, kicking us off, starting from Wales in the United Kingdom. We're going to first put you on the map. And if you've noticed, we've got a brand new map because we're running out of space. We thought we'd give you something a little more detailed so you know exactly where everybody is. Thank you, Ms. Behaven, for that question. Karen Reid to kick us off. Let's all just take a deep breath. It's a Sunday. We can talk about Karen Reid and not lose our minds. We're all going to play nice in the sandbox today when we're talking about Karen Reid. All right. Great question, though. She, Misbehaving, asked the question about Bukhenik in particular, and just, I think, the prosecution's case. And if I, watching this trial, am losing my mind by the police work done here, I will say this. There is no question that they made mistakes along the way and that there were things that they didn't investigate properly and things that are laughable, as Misbehaving says, in retrospect. But I will say I am not as losing my mind. I have not set my hair on fire as much as most might, because I've been doing this for so long that you really have seen everything, and you see incredible investigators, and I've worked with many of them, and they're my friends to this day. And then I've worked with really, really bad police departments, and they just do a very poor job. And what you have to do as a prosecutor, to your question, is not throw the baby out with the bathwater. Your job is to do the people's work. And sometimes the people's work is handed to you on a poop sandwich platter, and you just got to do your best that you can with it. I once worked with a police department that has now been disbanded. That's how bad it was. The county of Los Angeles disbanded this city's police department because they were so inadequate and had it swallowed up by the sheriff's department to do the actual police work in this one community. And I remember I had one of the officers in court, and I'm not even going to blame this officer for what I'm about to tell you. I blame his training, but he was in court, and we had a prelim, and I asked him, did he witness something taking place? It was about the recovery of evidence. I said, did you witness that taking place? Because I wanted to know whether or not I could put him on the stand. And he looked me dead in my eyes and said, do you want me to have witnessed it? And I looked at him and I said, dude, that's just not the way we're going to do things here. That's not the way we're going to handle this case. So we had to find other witnesses and we handled it. And my point being, misbehaving. Yes, there's a lot about this to get upset about with the police work. But end of the day, on the grand scheme and spectrum of horrible stuff, yeah, I don't even know if it gets in the lower half of horrible stuff, to be quite honest with you. Farm Girl, I think I missed you. Where are you? Thank you so much for gifting those memberships. Really, really appreciate your support. Great question to start us off. Wales in the UK. Let's keep it rolling.
Hi, Josh and the Courtroom Confidential crew. This will probably have to be a two-parter. I'm 79 Cecilia in the chat, and you probably wouldn't be able to pronounce where I live, but it's closest to Stockholm in Sweden. Last Sunday Fun Day, someone asked about Brokenbaker and how he can be a professional juror. Since he's Danish and I'm Swedish, there might be differences, but generally the Nordic countries have similar court systems. The persons you have to convince of the guilt innocence are a judge and several so-called lay judges, or professional jurors, as some say in English. The system is designed to get fair and unpolitical judgments of the cases presented, which of course means that the political parties nominate the person to become a lay judge. Yeah, because that's not contradictory at all. You serve for a 3-year period. It's not a full-time position, so you get paid based on time spent in court and possibly travel. You need to have suitable credentials according to the court findings, and then there is education about what exactly a lay judge is and what you can and can't do. You can also be appointed as a lay judge several times. As a side note, the Swedish court allows all the evidence to be presented, putting it on the court to determine the credibility, including hearsay statements. Continued in part 2.
I'm going to get to part 2, but I got to thank you, 79 Cecilia. This is great because she's answering a question that we had either last week or the week before about there's a YouTube creator called Brokenbaker who is a lay or a professional juror. And now we find out that that's also referred to as a lay judge. And she's answering that question about that because I was flummoxed. I couldn't find the answer to it. And this is a fantastic answer laying this out for us. So thank you for answering 79 Cecilia, and let's get to the second part of your question.
Hi, this is 79 Cecilia with part 2. I would say that our system isn't a perfect system, but at least there is some consistency with it. Here you can take a plea deal when it comes to criminal prosecutions. In civil cases, you can. After that lesson in Swedish law, I guess my question is, how come that in the US you can take a plea deal where you have to swear to the judge that no undue influence have been applied to you? When to me, it feels like you should be able to answer yes to that question and point towards the prosecutor. It feels abusive that the prosecution can up the charge and then say that, well, if you just admitted this part of it, then you might not have to spend as much time in prison or any time at all, depending on the charge. Or like what happened to Daniel Penny, having the prosecution going after a high charge and then allow that to be dropped when it looks like the jury might hang. Sorry for rambling, I have opinions, but sadly no hard answers about what will fix it so no country put innocent people in jail. Bye.
Great question. 79 Cecilia, not exactly from Stockholm, but she appreciates that I probably could not pronounce exactly where she's from, but we're going to put you on the map in Stockholm, Sweden. Look at this international crew already. I love it. Okay, this is a fantastic question because it talks about, the idea of taking pleas and whether or not that is done under undue influence. And isn't it always under undue influence when I've got somebody on the other side of the table who's telling me he's going to put me in prison, and I might put you in prison for a very long time if you don't go ahead and take this plea? Excellent point. Excellent question. How do we deal with that? And it's more about kind of on a ethical level. Well, in the US, we have something called Alford pleas. You may have heard of this. In California, we call them pleas pursuant to People versus West. But it's the same concept. It's the idea that sometimes a person may want to take a plea deal because they feel it's in their best interest to do so, not necessarily because they're admitting guilt. Now, does that mean we have completely innocent people admitting to crimes that they didn't do? No. I mean, has that ever happened in the history of ever? Perhaps. But usually if somebody is taking a plea because it's in their best interest to do so, they realize there is a significant amount of evidence against them and that the chances of going to trial and putting that in front of a jury is going to look so bad that maybe this deal being offered to me by the prosecution is the better way for me to get myself out of this trouble than to stand on my own virtue and feeling, feelings of complete innocence and take the chance. Now, you may not be completely innocent. You may be guilty of something, not exactly what you've been charged with. And I feel that most things kind of deal with that gray area rather than the black or white. But I wanted to give you an example of what this actually looks like. So there was a gentleman that you may have heard of that took a plea deal not too long ago that was pursuant to People versus West. And I'm going to show you what that looked like right now. And I'm going to have, of course, technical difficulty doing it. Maybe not. Recognize this guy? All right. This is Mel Gibson in 2011. He was charged with domestic violence. And here's the plea that he took in court.
Mr. Gibson, have you had every opportunity to speak to your counsel about the facts of your case, any possible defenses you may have, and the consequences of entering this plea?
I have.
And have you understood everything that your attorney has said to you regarding this?
I have a good grasp of everything my attorney has discussed with me, yes.
Okay. Now, along those lines, I have in my hand this advisement of rights and waiver and plea form.
Mhm.
Did you read and understand this form with the assistance of Ms. Burke?
I did read and understand this form with the assistance of Ms. Burke, Your Honor.
And are these your initials on page 1 through 3 and your signature on page 3?
They are, Your Honor.
Okay, did you put them there to indicate that you understood all of your constitutional rights, agreed to give those rights up, and understood all the possible consequences?
Yes, Your Honor.
Do you have any questions now regarding the rights you're giving up or the plea you are now about to enter?
No further questions for me, Your Honor.
Okay. Then Mel Gibson, in case 1WA 10655, as to count 1, Penal Code Section 243, subsection E, how do you now plead?
No contest pursuant to People v. West.
Okay. You do understand a no contest plea will have the same force and effect as a guilty plea, only in a misdemeanor it can't be used against you in a civil case. Do you understand that?
I understand that, Your Honor.
Does counsel join in the waivers, concur in the plea, and stipulate to a factual basis pursuant to People versus West?
Only as contained in the complaint, Your Honor. And if I may, as the Deputy District Attorney articulated, the District Attorney's Office in this case has agreed that resolving this matter does not require that Mr. Gibson say that he's guilty of the claims made by the complaining witness, but may maintain his innocence pursuant to People v. West, and does so now, and counsel joins.
Okay. In effect, he's entering this plea to take advantage of the plea bargain.
he's entering this plea
And to
because
have
it
it
is in
done
the,
with.
because it's in the best interest of his children. Yes,
Okay.
Your Honor.
All right. All right, then, Mr. Gibson, the court, having questioned you concerning your rights and reviewed this waiver form and questioned you concerning your constitutional rights, I find that you have expressly, knowingly, understandingly, and intelligently waived your constitutional rights. I find this plea to be freely and voluntarily made with a full understanding of the nature and consequences.
So that was Mel Gibson, 2011. This was a domestic violence case. He was pleading guilty to, pleading no contest, pardon me, to domestic violence charges. He got some probation. He had to do some community service. I've always loved that clip because if there was a face of a person who just wanted to scream the F word, that would be the face of that person. He was just seething with anger that he found himself in this situation. But I thought it was great for an explanation of what exactly is involved in these Alford or People v. West pleas. And yes, many times you're going to want to take a plea because you feel like it's in your best interest to do so, but you don't want to admit guilt. And as the judge explained there, usually that has to do with civil consequences. He was concerned that this plea would somehow be used against him for some sort of civil lawsuit, divorce proceeding, what have you, child custody issue. And he wanted to be able to put the criminal stuff behind him, not risk going to trial, not risk potential jail time. And yet still, suffer the conviction, but be able to deal with the civil consequences. You heard too that they talked about a factual basis. You have to put on the record that there is a factual basis for this. You cannot we are not going to allow people to plead to things when there is no factual basis for it. So you have to agree to that. And then it has to be voluntarily and intelligently given, meaning you cannot be coerced. And no, it doesn't count that you just don't like the government coming after you, but it's not that somebody's threatening you, someone close to you, extorting you to get you to make this plea. Interesting little tidbit about that. If you heard the attorney who whispered in his ear, that is actually Blair Burke, who you may remember. She's kind of one of these Hollywoody, high profile attorneys here in Los Angeles. And she recently, you may remember her name from representing Monica Cementelli. If you were following that case, she was one of the attorneys representing Cementelli in a case where she was recently convicted and going to be sentenced, I believe, to life without parole for murdering her husband, Fabio, right there. Really awful story, but that's Blair Burke in 2011 and now Blair Burke today, still working. So great question. Thank you so much, 79 Cecilia from Stockholm, Sweden. I hope that we answered your question. And let's keep it going here.
Hi, Josh. Kelly from Casa Grande, Arizona. Regarding the hearsay about Lori Vallow with the Charles's webcam footage, I just wonder why the police officers with the webcam cannot testify as to that webcam footage. Thank you.
Thank you, Kelly from Casa Grande, Arizona. First of all, your reward for calling in is that we're going to put you on the map. There's Casa Grande, Arizona. Yeah, zoom in on it. See how interactive this new map is, everybody? Let's do a little round of applause for Kaylin and the new map. Appreciate it. Now she's got a little more work to do back there for actually navigating the map, but I love it. All right. This is a great question. This is also kind of referencing a question we talked about a couple of weeks ago or last week. I can't remember. Everything melts together in my brain when it isn't, taking place this morning. But the question was about the videotape. We've all seen this of Charles Vallow giving statements to police before he was murdered, talking about how his wife, Lori Vallow, wanted to murder him. And why didn't that come into court? And the answer was, well, because it's hearsay. Now, Kelly says, well, wait a minute. Can't you just have the officer testify to the videotape and get the videotape admitted that way? Two problems with this, and this is why I love this question, because it is a difficult thing to kind of wrap your head around, even if you've gone through law school and been an attorney for years. But first of all, you have to start with the point of what is being said by Charles Vallow. Is that hearsay or not? Hearsay is an out-of-court statement. So is it first an out-of-court statement? Yes, it is. He's not on the stand making the statement. He's, outside of their apartment making the statement to police, and it just happens to be recorded. So it's an out-of-court statement. And are you offering it for the truth of the matter asserted? Yes, you are. You're offering it. The only purpose in offering this statement would be to show that Lori Vallow wanted him dead. If you're not offering it for that purpose and you're offering it for some other purpose, then it probably becomes irrelevant. What are we playing it for? And then you have to decide whether or not any exceptions apply. Is this a present sense impression? Is this an excited utterance? Is this a dying declaration? If none of those apply, then you've got yourself hearsay. And it doesn't really matter how you're trying to get it in at that point. Whether you're having the officer testify to what was said, then you'd be having the officer testify about an out-of-court statement that, by the way, is double hearsay at this point, because it's Charles is telling us what Lori said. So from Lori to Charles is one layer, and from Charles to the cop is a second layer. So double hearsay. Got problems with that. And then even if you just called the police officer to come in and lay the foundation for the video, saying, yes, this is a video I recorded. Here's my videotape. You've laid the foundation, but that videotape still has hearsay statements in it. The issue comes down to not whether or not we can prove somebody made the statements. It's whether or not we can cross-examine the person making those statements. And unless Charles Vallow comes in and testify, those statements aren't coming in. Obviously, we were in the murder trial of Charles Vallow, so he's not going to testify. But if it were, let's say, someone else testifying to that, then you've got ability to get it in. Then you could put that person on the stand. They could testify about what Lori said. Why do you get that in? Because now Lori's statement is a party admission, a statement made by the defendant that satisfies that hearsay exception. And that person would be testifying on the stand to that statement being made to them and could therefore be cross-examined about it. But you're not going to be able to get it in through the cop or through the videotape because you don't have Charles available. And I hope that either confuses you thoroughly or clears some things up for you. But excellent question. Thank you so much, Kelly from Casa Grande. Let's keep it moving. All right.
Alicia K. Mayo, Humboldt, Tennessee. Picture it. Odessa, Texas, 1961. Two 17-year-old students. Betty Williams, an easy girl from the wrong side of the track. Mack Herring, a popular football player, are no longer secretly dating, and Betty is distraught. She's been talking to others about self-annihilation and has asked Mack to do it many times. They were scheduled to be in a play together, and one night around midnight after play practice, he picked her up, and clad only in her pajamas, they drove out to a site Mack had chosen. He asked her for a kiss to remember her by before promptly shooting her in the forehead with the gun Betty chose. He then tied weights around her waist and took her out to the middle of a stock pond. He later confessed. His attorney, Warren Burnett, argued insanity, while psychiatrist Dr. Marvin Grice said Mack suffered from gross stress disorder due to Betty repeatedly asking him to end her life. First trial, the jury determined he was insane. Then the Texas Supreme Court reversed this, and he was acquitted during the second trial. Joshua, could and would this type of defense be feasible today? And as always, thanks, mods, chat, Joshua, and this kind of reminds me of the Bryan Kohberger defense. Thanks. Bye.
Oh, Alicia K. Mayo, thank you so much. Always good to hear from you. Calling in from Humboldt, Tennessee. There you are, very specifically on this map now that we have a detailed view of it. Great question. I love when I get these questions about cases I have never heard of. Never heard of this one. It is a shocking case about Betty Williams and Mack Herring. And Alicia Kay actually did a fantastic job of summarizing it. But yes, this took place in Odessa, Texas in 1961. And the story goes that Betty Williams was sexually active before marriage during a time where that was, to call it culturally taboo is probably putting it mildly. It was very unacceptable, religious community, small community, conservative community, different times. This was not something that a young girl did. And she became sexually active with Mack Herring. And then they broke up. And the story goes is that she could not suffer the embarrassment of all of this. Not just the embarrassment of him breaking up with her, but the idea that she had been sexually active with him outside of wedlock. It's really kind of hard to wrap our heads around it. But those were the times. And she had apparently approached several people with the idea of wanting to die and saying, could you please kill me? And people had said that they felt she was joking. Well, apparently she wasn't, or so the argument goes by Mack Herring, because Mack said she wanted to die and that it was this almost bizarre mercy killing. And yes, he brings her up to this water tank on a kind of abandoned part of a property, and not just a gun of her choosing, a 12 gauge is what he used to shoot her in the head, in the face, and kills her, weighs her down, and puts her in the water tank. Investigation's done. It leads to Mack Herring. He eventually confesses. And he has a trial, and it wasn't exactly two trials. It was like a determination of insanity and then a trial on insanity, where insanity was used as a defense. But yes, he was acquitted. He was acquitted by a jury for being under this kind of stressful situation of the moment that caused a temporary insanity. And Alicia Kay's question after that fascinating case, you guys should look it up. It's called the kiss and kill case, is would that same defense work today? Well, the answer is insanity, if available in whatever jurisdiction, absolutely is still a defense that's used today. So legally, there's nothing preventing this argument being made. But I think culturally, there is no way that would fly today. Your ladies and gentlemen of the jury, my client not only had sex with, then broke up with the victim, but because she was so distraught, he decided to go ahead and kill her because he was under stress as well. I mean, as the argument's coming out of my mouth, you can understand how it wouldn't fly today, but it was a very different time back in 1961 in Odessa, Texas. And people believed it. And I'm obviously not giving it kind of the detailed description of as nuanced as I could get in the short time that we have, but fascinating case. Just one horrific and horrible, and your heart goes out to Betty. But then also just shocking that that was a defense that actually flew with a jury way back then. All right, let's keep it moving. Crazy Mom RN says, not really the good old days, right? Good point. And then Captain Rhett Snuggler says, if you find Josh terrifically great, please acknowledge the thumbs up button. Thank you for that, Captain Rhett Snuggler. And I salute you for that, Captain. All right, let's keep it moving along here.
Hi, Josh. This is Maureen from Monterey. I have a question about how you, as an attorney, prepare your strategy for a trial. And I'm thinking specifically of something that I read former LA DA Vince Bugliosi say. And that is that when he was preparing for a trial, one of the first things that he did was to start his closing argument. And it was important for him to work on that from the very beginning so that I think what he was saying was that he could prepare the strategy for the trial. And I'm wondering if that's how you do it. And if so, when you're mapping out your strategy and starting to write your closing argument, how often do you get detoured or I don't want to waylaid or something like that because the trial takes a different direction than you anticipated when you were originally planning out your strategy? I don't know if that makes sense, but anyway, that's it. Thanks.
Thank you, Maureen from Monterey, California. Always great to hear from you. Let's throw Monterey on the map, first of all. Great question. How do you prepare strategy for trial? And she references Vincent Bugliosi, who was a DA here in Los Angeles, most famous for the prosecution of the Charles Manson family. And he wrote a book called Helter Skelter, which I have up there on my shelf. It's a fantastic book if you guys haven't read it. And I remember reading that book when I was first becoming a prosecutor. I think I was still a law clerk in the DA's office and just was really inspired by it because he talks a lot about his thinking and his philosophy and approach to being a prosecutor. And you're right. One of the things he talks about is starting from the end, starting with closing arguments. And I would say that's absolutely what you have to do as a prosecutor. Maybe not your closing arguments, but certainly the jury instructions. Anytime you had a trial, I would immediately pull all of the jury instructions, all of the law related to those jury instructions, because I don't care what wonderful themes you come up with, what incredible arguments, how charming you are, if you're not building a case beyond a reasonable doubt that satisfies all the elements of those jury instructions, then you're on a train to nowhere. And so, yeah, the first thing you do is kind of start with the end, get those jury instructions, print them out, understand them, and then form arguments around them. How am I going to prove this? And how am I going to convince people of proving it? And then to the second part of your question, Maureen, what do you do if you have to pivot? If something happens in the middle of trial? Sometimes judges make decisions you didn't see coming. Sometimes judges allow in evidence you weren't anticipating. Sometimes you get late reports on things and you're just going to have to pivot. The most probably one of the most important, if not the most important qualities you have to have as a good trial attorney, whether it's prosecutor or defense, is that ability to pivot, because it has to do with active listening to your case. The best people on cross-examination. You guys have all watched Alan Jackson cross-examine people now, and I know that a lot of you are fans of his talents. He's good because he's listening. He's listening to the words coming out of the witnesses' mouths, and he's pivoting and responding to that in real time if he has to. Crazy Mom RN, thank you so much. Appreciate your support. And the same thing goes with the case itself, not just witness to witness and answer to answer, but it is listening to how the case is playing out and pivoting and responding to that. Because if you're not actively paying attention to your case and you're just following your notes and the outline that you've written for yourself, you're not going to get very far and you're not going to do very well. So excellent question, Maureen. I really appreciate you asking about that and referencing good old Vinny Bugliosi. All right, let's keep it going here. Oh, Annalie Finch. Thank you. As always, great questions. I completely agree. Couldn't be doing this without you guys. All right. Let me see if I'm doing this right.
What's going on, Courtroom Confidential fam? This is Calypson's Vixen. I've got a minute and a half to record all of the questions that I have. So I love you all, but let's rapid fire questions here. So, Josh, personal question here as far as your professional career. As a prosecutor, now defense attorney, what was it like? Can you speak to what it's like to be in Jackson's shoes for the Karen Reed trial? Oh, by the way, Virginia on the East Coast, West Coast debate later. More on that. What was it like? Can you give some insight to what AJ may have going on for him, going from prosecutor in LA to now defense attorney, especially in a high profile capacity? I'm going to run out of time. The other really, really, really important stuff I want to talk about is federal court cases, criminal, civil, I don't care what it is, federal. So with the Diddy case, we are all kind of at the court watchers kind of beck and call here and taking their word for it.
Calypsons, I love you so much. You left a couple of messages. I'm answering everything that you left, but I'm skipping over to the last of your messages because I thought it was just very nice and I couldn't let it go without playing it.
Hey, it's Calypson's Vixen again. Just for the production team, y'all are fan-freaking-tastic. If nobody has told you recently, you don't have to play this one, by the way, because I've already left two that kind of have to be played together. But this was just for you. I figured y'all could enjoy the however long second voicemail I leave for just the production team. I do understand and respect what it takes to do what you do, especially not being the person that's on camera, pretending to know how to or not know how to operate things. We'll just leave that up for debate. But I see y'all, and Tisu's, Kylan, I know you guys have added some mods. I'm slacking on names. Forgive me. Scott, Recovery Addicts, Goldfish Brain is rubbing off on me, I swear. But I see y'all on the production side, and the mod team. Josh Ritter is the bee's knees, sure, when it comes to the face of Courtroom Confidential, but the production team is really where it's at. Sorry, Josh, love you. But lots of kudos to the production team. Y'all rock it.
No way I was not going to play that message. That is so nice of you, Amber, for leaving that message. And it's absolutely true. I fail for not thanking everybody involved in this channel enough. But yes, to our production team, Tiffany, my beautiful wife, and Kaylin, who is the rock star and does all things to making this possible. And even Eric. You guys don't hear much about Eric, but he is one of our editors that helps us put out the weekly roundup. And we're going to try to pull some teeth and get him on the channel one day so you can all meet him as well. And then to our mods, Shy Gal, Sonia, and Afton, you guys are all fantastic. So thank you so much, Amber, for pointing that out. To your questions. And I'm going to answer all your questions. I know I missed one of your messages, but first, what is it like to be in Alan's shoes right now? I have known, I'm sorry, Virginia. You're right. Put you on the map, Virginia. I have known, if you guys don't know this already, I've known Alan for 20-something years. We go way back. I was his law clerk when I was first in the DA's office. And then when I was hired as a DA, we were colleagues. And then I left the office and worked at his law firm as a law partner with him in his defense firm that he currently is still at. Known him for a long time. A big fan of his and the work that he does. And so I think I do have a pretty good insight into what AJ is going through and what it is like. I think we get this question a lot. You know, what's it like going from prosecution to defense? How do you handle that? Well, I think like myself, AJ would probably answer this question with that first and foremost, he is a fighter. He is an advocate. He is a lawyer, first and foremost. He is not, I think the best attorneys, in fact, are not so ideologically tied to one side or the other. In other words, if you are a zealous advocate, you can prosecute a case, you can find the strategies and arguments to prosecute a case, and do that just as well if the next week you are then defending a case, because you find the legal arguments and the strategies and the way to zealously get behind what you're doing. And I don't think it's so dyed in the wool that I can only prosecute people or I can only defend people. Some people are like that. Some people cannot see the other side of the globe. And I just don't feel that that makes for the best advocate. I find that the best attorneys on both sides of the courtroom are the ones who can actually understand and appreciate and probably do a good job if they had to switch sides. And Alan is definitely one of them. He excelled as a prosecutor, and he's now excelling as a defense attorney. To Diddy, your question on Diddy, and it was about the frustration that we all have with the fact that this trial is not being televised. And, you know, maybe we can get transcripts and we can submit FOIA requests and try to get these transcripts later of what's taking place in court. And reporters are allowed, it's not a closed courtroom, but reporters are allowed in. They're taking notes by hand and chiseling it in stone like caveman times. But why don't we have televisions in court? This is a modern time. We live in modern ages. We all have interest in these cases. And this is a very important and fundamentally a case that I think a lot of us are curious about the outcome. Well, you need to talk to John Roberts, Amber. Your question was, what do we do? How do we get it? Write a letter to this gentleman right here. That is the Chief Justice of the Supreme Court of the United States, and they control all of the federal courts and the rules behind them. There is a rule called Federal Rule of Criminal Procedure number 53. Ask them to change rule number 53, which says that recording devices, cameras, even still cameras and video are not allowed inside federal courtrooms. And I don't have a reason for you why. I do not have a good reason for you. It used to be about protecting the sanctity of the trial and making sure that outside influence didn't seep its way in. We're way past that. We live in a very different time than when these rules took place. And I do not think it adds to the transparency and appreciation for how justice is done, because people are always going to have a problem and question if they can't see it. The best, what is it? The best disinfectant is sunlight. And I agree with that completely. If you really want people to trust the system, then show them the insides of the system. Calypson's Vixen says, oh, okay, so I just need to bug the heck out of him. Got it. Yeah. If you want to put a letter writing campaign to Chief Justice Roberts, go ahead and feel free to sign my name to that. But that's what needs to be done. But it is, I completely share your frustration. I don't think it makes sense. And I think they need to change it. And I think they will, because it's just ridiculous at this point. One of the great things about the American system is that it is open and that we do allow cameras, except when it comes to federal court. So same thing with the Supreme Court. I think it's ridiculous that we don't see the inside of the Supreme Court. Do you know that there is only one photograph that has ever been taken inside of the Supreme Court while they were sitting, by the way, not like an empty room, but while they were sitting hearing a case, somebody years ago snuck in a camera and took a picture. Why? Why is this like Wizard of Oz nonsense taking place? It just doesn't make sense to me. So that's the guy you want to write a letter to, Amber. But thank you so much for the question. And thank you so much for the very kind words for the whole team here, making Mr. Ritter look good. All right, let's keep it rolling. I just want to make sure I'm not missing anything. Okay.
Hey, Courtroom Confidential. This is Holly in Houston, Texas, calling in with 3 questions with a bit of musical entertainment in the background, guys. Yes, that's right. My kiddo is practicing his acoustic guitar for homeschooling. So completely unintentional, but it has a nice ring. So we're going to move on. Question 1. How is it determined if someone is a serial killer or not? What criteria is used? What does that look like? How do they figure that out, whether or not to classify it as such? Question 2. What is the most memorable client you have represented and why? And question 3, not asking for favorites, just what is the most interesting interview that you have had on other platforms? What was the platform and what was the topic so that we can go find it and have a watch for ourselves too? Okay, thanks guys.
Thank you, Holly from Houston. Always love hearing from you. First of all, let's put you on the map. Houston, Texas, Holly calling in with 3 excellent questions. And there is Texas, in case you were wondering. Right on the Gulf of America / Mexico. Let's not fight about it. All right. First, what is the FBI definition of a serial killer? This was a great question, and this is what I found, and this is funny to me because I thought you guys would enjoy this. Let me make sure I can do this properly here. Yeah, here it is. I found this online. This is a PDF that I downloaded from the Department of Justice. It's the U.S. Department of Justice Federal Bureau of Investigation, FBI, Serial Murder Multidisciplinary Perspectives for Investigators. You can download this all for free. It's fantastic. And one of these chapters here, I don't know if you can see it, is definition of a serial murderer. And they go into great depth talking about how this isn't as simple as you think, because there's some things to think about. First of all, is a serial murderer the same as a mass murderer? In other words, if you commit a bunch of murders at once, and let me see if I can zoom in so you guys can maybe see some of this. Oop, and I messed it all up. Oh, Lordy. What did I do? How do I get the chapters back? Oh, shoot. Kaylin, run over to my house and fix this for me. All right, I'll keep talking while I try to find it here for you guys again. But it talks about how, a mass murder is not necessarily the same thing as a serial murderer, right? That there has to be kind of some time taking place in between, some period of time in between the murders for it to be classified. Here we go. Where are we going? There we go. Oh, Lord. So a mass murderer would be somebody, interestingly, like, if proved to be true, Bryan Kohberger, right? One event, 4 people killed, not a serial killer. Wrong to refer to Bryan Kohberger allegedly as a serial killer. So then what is a serial killer? Well, I don't want to mess with this so that I lose my place, but if you can see here, their definition, according to the FBI, and to answer your question most straightforward, Holly, is the term serial killings means a series of 3 or more. So interesting, they don't count 2 as serial, but 3 or more, not less than one of which was committed within the United States, having common characteristics such as to suggest the reasonable possibility that the crimes were committed by the same actor or actors. There you go. So 3 or more killings in a series, series meaning time taking place in between. And then they got, if it's the FBI getting involved, obviously it's taking place in the US, and there's some sort of reasonable possibility that they were committed by the same actor because they share common characteristics. So just a little interesting thing. If you guys want to download this, you can find it. It's on the Department of Justice website, the Serial Murder Multidisciplinary Perspectives for Investigators. All right. Hold on. Then to your next question. I don't know what I'm doing here. Hold on. Okay. To your next question, Holly, was what is the most memorable client that you have represented and why? I'm going to tell a quick story. I've told this full story on one of our members only lives. If you guys, for another reason that you might want to join our membership is that we tell lots of stories, and I give you lots of kind of little interesting tidbits on cases I've worked on. And I don't want to steal this good info away from the members only, but there was a case that I worked on a while ago. It was actually the first case that I worked on as a defense attorney. I left the office, joined Alan Jackson's firm. First case out, he says, I want you to meet a gentleman. He's charged with murder. You're going to help me defend him. And it was a man who was a hotel owner in Venice, California, charged with murder. Long story short, we handled the prelim of that case, and we actually won the case at prelim. The judge kicked the case. Unheard of. Actually made the rounds in the DA's office. Really, really fascinating set of circumstances that led to that. And a lot of people in the office were impressed because one, prelims are never kicked, never dismissed. And two, certainly not murder prelims. I've never heard of it happening before that case in my entire career. And many people had never heard of it happening. But this guy, this client, we became very close, obviously, while we're handling his prelim. And we've become close since then. And it's the most memorable client I have because he's still a very, very good friend of mine to this day. He was at my wedding. He is a person I speak to on a monthly basis, at least. We'll go and grab dinner together. We'll go and hang out. We've done vacations together. He's a fantastic guy and a big part of my life, and I love him to death. And that is the most memorable client I have. So thank you so much for giving me an opportunity, Holly, to talk about that. And then your last question is, what is the most memorable interview I have ever done? And it's going to ask me to perform technology again, but you may recognize this lady right here in this interview that I did with her.
Josh Ritter, when you end up behind bars, guys, Joshua Ritter is a renowned criminal defense attorney, former prosecutor, and host of Courtroom Confidential on YouTube. You can find him at joshuaritter.com. I'm always amazed that people lead a life of crime, and when they end up behind bars, they're like, what? This is awful. Okay, yeah, it's jail. But do they not understand that a life of crime leads to incarceration?
Well, I think one thing that criminals don't do is think about consequences. Most of their life is lived on this idea that they're going to get away with it. So, yeah, there's a lot of rude awakenings when they end up behind bars. It's an incredibly uncomfortable, is not even the right word for it. It's an incredibly horrible place to be in. I mean, you're first of all, you're lacking all kind of comfort. But secondly, as we're finding out, it's also incredibly stressful.
A horrible place to be in. How do
you
you think those women feel when they wake up the next morning, still greased up with baby oil infused with GHB, gamma hydroxybutyrate, with their vagina hurting? What about that? And you're telling me jail is a horrible place to be? And
yeah, well, no, you're absolutely right, and that's why he's.
You ever wake up one morning covered in baby oil with your rear end hurting, Ritter?
I have not. No, I cannot say that I've experienced that. But
well, lucky you. I guess you didn't go to a white party.
Yeah, that's my most memorable interview, Holly. I got to say this. Nancy Grace is an absolute hoot. I mean, she first of all, I've been on her show quite a few times. She loves to pick on me. She loves to fight with me. She wants me to fight with her. She, by the way, off camera, one of the sweetest, nicest, most generous, kind people you ever want to know in your entire life. But she loves to just turn on that camera and get into a fight. And I cannot think of the last time that I was literally speechless, but I don't know how I answer that question. I feel like I just wanted to crawl up in a ball. And they kept it in the show, and I said, okay, great. Well, we're going to put it up on our website. So there you go, Holly. Thank you for asking. That is by far my most memorable interview that I've done so far. All right, let's keep it moving here. Hold on. I'm going to figure this out. All right.
Hi, Josh. This is Hazel. I'm calling regarding the Aliza Sherman case. I haven't heard any updates lately. I'm wondering if there's anything that you can share with us or any news you can report. Thank you so much. Bye.
Thank you so much, Hazel. Great question. She asked about the Aliza Sherman case. Interesting, fascinating case. Woman was allegedly killed by her own attorney so that he could so that he didn't have to go to trial. Pretty fascinating stuff. But I got to tell you, I didn't have an answer to this. I was a little bit stumped, Hazel, and we would have put you on the map, but you didn't leave a location, so sorry about that. I was a little bit stumped, Hazel. I said, but I wasn't beaten. And why is that? Because I could phone a friend.
Josh and crew and Grizzlies in chat and everybody else, happy Sunday to you if you're watching this live, of course. I am so glad that you asked this question because I feel like not many people are following Aliza Sherman's case, and yet I find it so interesting, especially because her case was a cold case for over a decade. She was stabbed to death on March 24th of 2013 outside her divorce attorney's office. And guess who they arrested 12 years later? Yeah, her divorce attorney. So now all the updates are about him, of course, because he's sitting in Texas, even though the crime occurred in Ohio, because he'd been out there visiting some relatives. Apparently a relative actually passed away. I read something like that. So now they need to extradite this guy. So he waived a formal extradition hearing in Texas. Ohio now has 30 days to get him back to Cuyahoga County, and they said that they will be driving him and not flying him, so he's not getting the Kohberger treatment, okay? And then his legal team in Texas is asking for the prosecutors in Cuyahoga County to outline in greater detail just exactly why they've charged him with this, and I'm thinking, but that indictment was very detailed. I mean, it was really very interesting to read. So those are the updates for now, and let's all keep a close eye on this one.
Oh, my word. Oh, Gisela, I love you. Thank you so much for doing that. That was, of course, Gisela from Grizzly True Crime. I'm sure that I don't even have to tell you that. Big thanks to her. Big thanks to the Grizzly tribe and everybody who is here watching. We get huge support from all of the Grizzlies out there, and I'm so appreciative that Gisela was able to take some time to answer that question for us and to tease me a little bit for my weak attempt at a flattering impersonation of her. Oh my word. Love you, Gisela. Thank you so much for being here today too. And thank you for taking the time to do that. So Hazel, appreciate you for asking the question. That's the latest updates on Aliza Sherman. Next time, Hazel, let us know where you're from. Where are you from, Hazel? You're here. Let us know where you're from so we can throw you up on the map. And big thanks again to Gisela and the Grizzlies. All right, let's keep it going.
Hey Josh, this is Debbie in Kentucky. I am south of Scottsville, Kentucky, close to the Tennessee border. My question is about jury selection and information. You mentioned, I believe, a while ago that the attorneys, both defense and prosecuting counsel, all get the information from the jurors. I'm assuming that includes addresses, phone numbers, the answers they give for their questionnaires. And I am just wondering, in the case of Lori Vallow Daybell and others who represent themselves, is she getting access to that personal information? Because if I was a prospective juror, I would not want her knowing my personal details, and just wondered how that works. Thanks a lot. Love the show. Bye.
Debbie, thank you so much. Hazel says she was nervous. You don't need to be nervous. Hey, it was a great question. Debbie, thank you so much from Scottsville, Kentucky. First of all, let's put you on the map. There's Scottsville. Zoom out for us a little bit, Kaylin. Let's see where that is. Right smack dab in the middle of the country. So Scottsville, Kentucky. Thank you for calling in. Question about Lori Vallow and jury selection. Great question. What information is given to attorneys, and especially if that attorney happens to be a convicted murderer and also charged murderer? Do they know where these people live? Do they know their names? Do they have their contact information? Here's what I can tell you at least about Los Angeles and California. First, you do not have the information handed over to the attorneys is not everything about a person. The most you will have is that person's name. In California, we take great lengths to, even in cases that aren't high profile, not use people's names for jurors in court. So you will always be referred to as your jury number. So we will receive a list. It will have the name of the person. That's mainly for the attorneys to make sure that there's nobody on that jury list that they know. And then it will have a number next to that person, a randomized number. And they were always referred to by that number or their seating number. There's no address. There's no phone number. There's no where they work, all of that kind of stuff. This is in California. I am not sure about other jurisdictions and how much information they get. But I will tell you, I have handled per cases as well. That information is not shared with the defense. They will get a randomized list, but it will have redacted information. And these lists are taken back every single day. So it's not something they can take back with them to try to research people. So I hope that puts some of your fears to rest, but I am sure that steps were taken in the Lori Vallow case so that she couldn't find out who these people are, because I am sure those jurors were asking the same question. And I imagine they had that question asked of the judge before they even sat on this case. I would want to know the same thing. So Debbie from Scottsville, Kentucky, fantastic question. Thank you for asking. Let's keep it rolling here, guys.
Hi, Josh. This is Gina, aka Tangling with Gina sometimes, from Chapala, Mexico. I found out this week that my husband does not like my response to when he asks me the same question 3 times in 1 hour, and I respond, ask and answer, move on, please. I don't know why, but I do have a question, and here's my question. As a prosecutor, what was your most interesting case that you prosecuted? Could you tell us about it? Thank you.
Gina calling from Chapala, Mexico. I love this one. Let's first of all get you on the map. I have not, I don't think we've had many from Central or South America. So thank you for representing from Mexico, Gina. You ask, what is my most interesting case that I have prosecuted? And if I'm going by interesting, I'm going by what is interesting to me. And that usually has to do with the complexity of the case and how difficult it might have been to prove. So I think my most interesting case, or at least the one that came to mind, is also my most difficult case that I've had to prosecute as a DA. And that was a cold case. It was a case from the 1980s. It was a case that involved self-defense. It had gone cold because they could not find the defendant for a long period of time. It wasn't one of those cases where they didn't know who the person was. They knew who their suspect was. They just couldn't find him. And so for 30-something years, they weren't able to locate this person. And then by the time they did, now he's charged with murder. And I've got no eyewitnesses that we can currently find. This took place in a lower income area of Los Angeles. Nobody's around. No history of where these people live now. I've got police officers who have no idea about this case. It was 30-something years ago. Yeah, I wrote the police report. I remember I called up the medical examiner, this wonderful woman who had long since retired. And when she answered the phone, I said, "Hi, this is Joshua Ritter calling from the district attorney's office." She said, "Oh shit," because she had thought she had put that career entirely behind her. A wonderful lady, though. Everybody came in and had to testify based upon refreshing their memory and past recollections recorded and all of this kind of stuff to just slog this case towards its very end. And it was first of all, I won. I guess it wouldn't make the list if I hadn't won. But it was just a fascinating case that finally the way we were able to combat and get past the idea of self-defense had a lot to do with bullet trajectory reconstruction. In other words, where was the person, the victim, situated? Where would the shots have come from? Where would the shooter likely have been when these shots were taking place? We could actually place which shots took place when, because one shot was a fatal shot and would have dropped the victim like a sack of potatoes. So it was this very interesting kind of forensic way we were able to patch it together. He also testified. And this is another case that I talked about on a members only live. You're giving me guys lots of opportunities to advertise our members only, our members program here. But I showed the whole PowerPoint presentation, and maybe I'll do it again in the future. But this whole PowerPoint for my closing and how we were able to use the bullet trajectory and the interview of the defendant and his testimony. And it was that was a case. If you're asking me what was my most interesting, the first thing that came to mind was that case. So thank you so much. Gina calling from Chapala, Mexico. Appreciate you. Discerning 8 says, "Hey Josh, how are you? I was on the Court TV commercial with you. Oh yeah, I was right after you. I moderated for Court TV. Oh, fantastic. Good to see you. Yeah, I do. We'll have to find that video. That was a very funny kind of patchwork of people they put together reacting to the O.J. Simpson case. Thank you for that, and thank you for the super chat. Good to hear from you. All right, let's keep it going here. Great questions, guys. What have we covered so far? We've had Aliza Sherman, and we got a little bit of Nancy Grace, and we got a little bit of Mel Gibson, and we yelled at Chief Justice John Roberts a little bit. Really great stuff. Thank you guys so much again for all these calls. All right, I don't want to miss my place here. Here we go. Oh, sorry. All right. I didn't do this right.
Hello, friends. It is Madeline from Denver again, calling with a not popular case question. As someone who has had to report to a coroner about a loved one and then read their autopsy report after that, I understand how things can easily get very misconstrued. Example being, I reported that my loved one would have maybe one drink with dinner one time a month. And on the autopsy report, it said regular alcohol abuse. Clearly not the case. So as a prosecutor and as a DA's office, how much do you just trust the autopsy report versus talking to the family or, other circumstances? Like, how can you trust that when something like my situation where one drink once a week became alcohol abuse on the report? Thank you, friends.
Thank you, Madeline, from Denver, Colorado. So first of all, let's put you on the map in case you guys were wondering where Denver, Colorado is. That's where Madeline is. Thank you for calling and leaving this question. I'm going to extend your question. You're asking, do you ever just kind of do you just trust the autopsy reports? And I'm going to extend that to saying, do you trust any report? And the reason I'm doing that is because it sounds like really your question had less to do with the science, the actual examination of the body, than it had to do with input received by the coroner that was also included in the report. So coroners will do this. They will interview people. They will take other information. They will, because they have to do two things. They have to determine the cause and manner of death, right? So if you're looking at the cause of death, you can see blunt force trauma. You can see a sharp object used to, slice someone's neck, whatever it is. But then you have to determine manner. Well, manner, homicide, suicide, accident, undetermined, or natural causes, that requires a much more holistic approach and surrounding circumstances. And those surrounding circumstances might be statements made by witnesses. But I can almost guarantee with you, Madeline, I might be wrong, but that the information you didn't give exactly to the medical examiner, but to law enforcement who then gave it to the medical examiner. And that's why I'm saying, let's talk about all reports and whether or not those can be trusted by a prosecutor or defense attorney, quite frankly. I think you would be foolish on whichever side you're on to take these as gospel. You have to understand the purpose of a police report. First of all, many times they're taking statements on the fly. These are investigators who are considering a very fluid and sometimes fast-moving situation. They're contacting people. Get me your name. Who are you? What did you see? Jot down a few notes. They are not transcribing. Many times they're not even audio recording. And then they're taking those notes and handing those notes over to an investigating officer. And perhaps that investigating officer is then transcribing those notes into an overall report, or maybe you're writing your little small part of the report into the overall report. But then an overall report is compiled and put together. And in there, it will say, Officer so-and-so, Officer Lopez, spoke to the witness and the witness said X, Y, and Z. Well, that is not only based upon probably not an audio recording, but contemporaneous notes being taken by Officer Lopez. And they're trained on this. They're supposed to be accurate. But then it's also, you're playing the telephone game because it's going from Officer Lopez to the investigating officer to whoever's writing the report. So the way to use these police reports are much more to get an idea of who you need to talk to if you're going to put on a trial. If I were the prosecuting person, I am never putting someone on the stand expecting their testimony to be exactly what's in the police report. I am putting them on the stand after I've spoken to them and confirmed everything is true or accurate or needs changes in that police report. Now, what's also interesting about that is you can impeach someone based upon that police report because it is a statement that they gave before, but you're not really impeaching them by the police report. To complete the impeachment, you need to call the officer, and then the officer needs to say that is in fact what that person told me. And now you're going off of the reliability and memory of that officer. So that was probably a much more complicated answer to a simple question than you expected, Madeline, but I appreciate you asking because I think sometimes we do have the mistaken impression that these police reports are intended to be, verbatim transcriptions of what people are saying. And many times they're cliff notes, they're quick summaries of what people have said, and many times they do include inaccuracies. Now, they are never supposed to include false statements, but they might include quote unquote inaccuracies. But great question, Madeline from Denver, Colorado. Let's keep it going here. Oh, Louisa, thank you so much for the super chat. Appreciate you. What did I do? All right, here we go.
Hi, Joshua Ritter, Esquire, and listeners. This is Denise from Australia. In regard to Lori Vallow's last trial, she requested not to have to wear obvious physical restraints. So the compromise was the waist of the stun belt. But I did a quick search, and there was a news report, and the reporter wouldn't put the belt all the way around because he was told of the force of it and how long the bolt lasted. I think it was 8 seconds. So what do you think of that? Does it seem a bit extreme? Thank you.
Denise from Australia, thank you so much for the phone call. Let's put Australia on the map. It's a little island in the South Pacific you may have heard of. Thank you so much for calling in. We get a lot of people calling from and listening from Australia. So we got a big fan base out there and we appreciate it. We say hello to all of our Aussies. You asked a question about Lori Vallow and the fact that she was wearing a stun belt in court. And I think if I understood your question correctly, you're saying a reporter was talking about it, and even the reporter wouldn't put the belt all the way around because they did not want to risk experiencing what that belt, that voltage may have felt like. And you're asking me, do I think that's a bit extreme? Well, I guess it's extreme only if you run. Because here was the alternatives. The alternatives was, listen, this is a person who's already been convicted of murdering their own children and they're serving life in prison. Now they're on trial for murdering someone else. That is not a person a judge is going to let walk around freely in the courtroom. But you're confronted with the issue of she's going to represent herself. So how are you going to handle that? How are you going to allow her to walk freely enough to examine witnesses, cross-examine witnesses, speak to the jury, and you've got this person shackled? You can't do it. So the judge decided to compromise and put a stun belt on her. Even when defendants aren't representing themselves, they will have their shackles removed to some extent, but there's usually a deputy sitting right there and they're not going anywhere. So you've got a little bit of a special situation in that this person has to be able to kind of walk around more freely. So they decided on the stun belt. And yeah, I guess it sounds extreme in the sense that it does sound like it might hurt like a son of a gun. And it sounds like it's something you don't want to mess with. But I don't want to be sitting in a room with a convicted killer on trial for another murder and have that person be able to freely roam the room. And I'm not just talking about them running for the door. What if they run for somebody else, somebody on the stand, a juror, a judge, what have you? I think everybody felt a little bit more safe. Afton says, anybody remember Deborah Redden? I don't remember Deborah Redden, but I will look that up, or maybe somebody can share it in the chat. But thank you, Afton. All right, let's keep it moving. Thank you so much, Denise from Australia.
Hey, Josh and Courtroom Confidential. This is Amanda, also known as Super Planner Girl, and I had another question for you. Oh, and I'm not going to forget my location this time. I am in Augusta, Georgia, where it is already ridiculously hot. My question for you is motivated by the Karen Reed trial, but not necessarily about the Karen Reed trial. As we all know, it's a very controversial trial with people feeling very strongly about the way that they feel, whether it is for her guilt or for her innocence. And I'm just wondering your thoughts on kind of the, I don't know, the harshness, the strength of these feelings, why you think it exists with this case or any case. Do you think it's because we're in this true crime saturated world, or do you think it's just the nature of human beings? It's almost like a bandwagon mentality, it seems. And I just want to know your thoughts on that. And if you can offer any insight, and I would appreciate it. Thank you guys for all that you do.
Thank you, Amanda from Augusta, Georgia. Let's put you on the map. Thank you so much for calling in. I love this question. I love this question. Amanda is asking about the Karen Reed trial, and why does it seem like this trial is causing such strong division amongst people? First of all, I will say it's really unfortunate that it is, because one of the things I love about the true crime community, if you've ever been to Crime Con, you see this in actuality, but you see it every single day in our chat. And, when you deal with people who are creators and other YouTube channels in this space, it's an incredibly welcoming, wonderful community of people. And then every once in a while, there will be a case where it starts to kind of bring out the edges in some folks. And I get it. I get that we feel passionately about these things. And I get that we feel, especially if we feel like injustices are being done. But it really has, in this case, led to a weird and ugly place. And not so much on YouTube. I see it more on Twitter, but with the name calling and the kind of viciousness about this whole thing. And why this case, putting aside all of that, I'm also fascinated as to why this case is so popular. She's not a celebrity. This is not some sports figure or some celebrity. John O'Keefe was a police officer and sounds like a great guy, but he's not some celebrity. I mean, we've never heard of Karen Reed and John O'Keefe or the Bryanses before any of this. Trooper Michael Proctor, never heard these names in our lives. None of this makes sense as to why it's so popular. It's a case of, at best, local interest. Also, the crime itself is not all of that salacious. We're not talking about multiple murders or some sort of horrendous circumstances of the murder. We're talking about somebody allegedly running over somebody with their car. Why? And I've thought long and hard about this. I think, one, it's a circumstantial case. I think those cases are always kind of fascinating. We're always a little, more, our attention is more piqued by circumstantial cases because there's, we're not talking about eyewitnesses. We're not talking about caught on video or a confession where it's kind of like game over. It's like there's still some mystery attached to it and, something that needs to be proven and convincing and arguments. It's got great attorneys. I think that's part of it too. You've got Alan Jackson and his whole squad that are just fascinating to watch. I think, though, it's probably these last two elements. Yeah. And Simi Sharp nails it. I think it's these last two elements, the idea of police misconduct and the idea of conspiracy and a cover-up, that really have sunk their teeth into a lot of people, is that they watch this and they go, this is an injustice to me. Or they go, I can't believe that this person is being railroaded. And then you've got people on the other side saying, I can't believe you believe that. I can't believe you believe that this person's being railroaded. I can't believe that you believe the police are being corrupt in this whole thing. And that is, I think, where people are really starting to get personal about the whole thing. I think it's unfortunate. I really do, because I think it's a case I would love to, dig into, but I also know it's one of those cases that it's like, I feel like you're walking on thin ice so that you don't offend others. Maybe not so much in our community, in our chat, but it does seem to be one of those things that just has got people worked up. So anyhow, great question, Amanda. Thank you so much for asking it. I am fascinated by the whole thing, and we'll see how it all turns out, and hopefully the world will keep spinning and the sun will continue to rise and set. All right, let's keep it moving here. Seeking Justice says, happy Sunday. Love the CC family. Well, we love you, Seeking Justice. Thank you so much for that support. Oops, what am I doing? All right.
Hi, Josh and the team. My name's Lynette and I'm from Exeter in England. My question is, with the Karen Reid trial, if she's found not guilty and all the evidence that the defence are shining on Bryan Higgins and his mates that may be the culprits, what happens after the trial? Do the police then open the case and investigate Bryan Higgins from the evidence that they've heard? Or is there nothing done and then the O'Keefe family don't have anyone to blame? Many thanks. Love your show. Take care. Bye.
Thank you, Lynette from Exeter, England. I love it. I had to look that up. I'd not heard of Exeter. And that don't throw stones at me. I probably should have, but Exeter, England. Appreciate you calling in. And right on cue, a Karen Reid question. Of course, you can always ask them, but it is just funny, the timing of it. Lynette's question is actually a very interesting one, and I think it kind of goes beyond the controversy that we were talking about, because she's asking, listen, if there is suspicion being thrown at the feet of other people, Bryan Higgins, for instance, and there does appear to be tomfoolery, fooling of the Tom taking place here, what is done? And, you know, you could apply this to any case. If you have a case where there are alternate suspects being presented by the defense and that person is acquitted, what do you do with the alternate suspects? Do you pursue those? Do the police go after those? The idea here, most directly, but even in most cases, is that these alternate suspects are not the suspect for a reason, and that the police, and again, if we can just speak in generalities and not speak so much about the Karen Reid case, but the police have looked into these alternate suspects and for whatever reason ruled out those people. And for whatever reason, a judge is allowing the defense to still argue it, but doesn't necessarily mean if they lose their case, you work yourself down the rung. Well, that was chief suspect. That didn't work out. Let's go to secondary suspect. There's a reason why that person is not their chief suspect. And that is the police somehow believe that that person has been cleared. So I don't think there's any chance we're going to be seeing Mr. Higgins here, in handcuffs anytime soon. And quite frankly, too, think about a world that would be where the police just switch gears. Oh, that person didn't do it. Let's go after the second person. Just not think about how drastic that change would be and how outrageous we would all find it to be. And it would completely make us question what the police are doing beyond the questioning we're already doing. So excellent question, Lynette. But yeah, I would not suspect that we're going to be seeing, if Karen Reid is not convicted, I think that's the end of the story as far as for the O'Keefe family. All right. Let's keep it going here.
Hi, Josh. I love your show. My name's Katie and I live in Nantwich in England. I'm very interested to know how and when information about a crime is deemed suitable to be shared with the public. In the weeks leading up to court cases, there seems to be a slow drip feed of information. For instance, say the presence of a knife sheath found next to a victim in Idaho, and then one of the parents of the murdered girls shares horrific details of what's been done to his daughter. And we have CCTV released 1 minute and phone records the next, in no particular order. But who decides what should be released and when? And should we know any of it, and who benefits? Thank you very much. Bye.
Thank you so much, Katie from Nantwich. I'm probably butchering the pronunciation of that. England. Thank you so much again. Representing England. England running deep today. Great question. When is information about a crime deemed suitable to be shared with the public? The answer to that is, once it's presented in court, is the final answer. Now, it's really up to, unless there are gag orders in place, but it's really up to the prosecution and the investigators how much information they want to share ahead of time, because they are trying to preserve the integrity of their investigation. And they don't want information getting out that will either, one, affect potential witnesses in the case, somehow appear to attack the integrity of the suspect that they have. And then there's also the concerns about how much information is out there that the public will know about, and will that affect jury selection? So, the prosecution's not going to just be like, here's everybody we're calling, and here's everything we intend to prove, because the judge would shut it down and say, you've completely tainted the jury pool. But you will see prosecutors say, we believe this person. Here's some of the reasons for that. The feds love to do their little press conferences where they talk about the indictment and everything they've released. But the answer is, once something is in court and presented in court, whether that be through documents in pretrial hearings, or whether that be through witnesses and things presented on the stand, that is now considered public. Anything in a public courtroom is public and good for everyone to use. And they will, and the press will run with whatever is given to them. But before then, depending on gag orders and everything else, a lot of that is kept closely, close to the vest, as it were. But you're right. We did seem to get this slow drip of information, just to go back to Kohberger. And then we had that Dateline episode, which was just mind blowing. And a lot of that was leaked information. So to answer your question, Katie, though, that was not deemed suitable for the public. That was something that was leaked to the public. And the judge really wants to see some accountability for that. He was not too happy with it. Thank you so much, Katie from Nantwich, England. Let's keep it moving here.
Hey Josh, this is Jill from Kirkland, Washington, across the lake from Seattle. And I have a question for you. I watch a lot of these trials, and what is the person doing that generally sits in front of the judge, and it looks like he or she is holding something up to their mouth? Are they talking into it? What is that? I've really tried to figure that out, and I can't. So hoping you can tell me.
Thank you so much, Jill
Thanks,
from
bye.
Kirkland, Washington, for calling in. Appreciate you. Let's put Kirkland, Washington on the map, as you say, just across the lake there from Seattle. Great question. A lot of people have wondered this. And I think the reason we're all thinking about it more than we may have before is the Karen Reed case. I have never seen this before, by the way. But what this, I'm going to put, if we could put up that picture there, Kaylin, what this person is wearing, you see the person there in the bottom right. They've got this kind of Darth Vader-y looking mask up to their face. Maybe it's more like a Bane mask up to their face. That person is the court reporter. I am used to a stenographer, somebody in court who is, typing in shorthand everything that's being said. That person is actually trained to what's called revoice what's being said in court. So they're listening to people and in real time speaking the same words into this mask. If you think that's impressive, by the way, I think that's impressive. I don't know how you keep your brain straight, listening and speaking at the same time and repeating everything to a degree of accuracy. I have seen courtroom interpreters, meaning translating from English to Spanish, who do not need a break, who can real time hear the words being spoken in English and not only speaking it back, but translating it into another language and speaking it back in real time. Really impressive stuff. So they speak into this steno mask, as it's called, because they are creating the official transcript. And sometimes that is being then transcribed later from recordings, but I believe here they're actually using voice recognition technology to give them a transcript. Now, you might say to yourself, why, I mean, if she's just listening and saying, why not just audio record everything in court? The answer is because we need one official transcript. You've heard the audio in court. If somebody steps away from a microphone, you might miss something. If somebody misspeaks, you might not catch that they misspoke. You need one person, the court reporter, deciding what is the official record of what has been set in court. Because you don't want attorneys going back and saying, well, I hear this. And another attorney says, well, I hear this. Or I thought the witness said X, but according to the audio, you can't tell what they're saying. All sorts of confusion. That's why, for the same purpose that the stenographer, the court reporter typing on keys, what they hear and what they write down is gospel. I don't care what you heard in court or what you thought was said. If you don't make sure that the court reporter gets it, you've got problems later on. And that's why a good attorney will always be making sure that the court reporter is keeping up with them. You know, every once in a while, I'll make a little eye contact, check with the court reporter. Are you keeping up with this? And repeating things for the court reporter, spelling out things for the court reporter, describing actions that have taken place in the court reporter. For the record, the witness just raised their hand as if they were holding a knife and did a stabbing motion going forward. All of this stuff is important if you want it to be part of your court record. Otherwise, it's getting missed. And that's why they have one person. And in Massachusetts, I guess they do it this way rather than the old school way that I'm used to. I don't know why. I don't know if there's an advantage to that or if it helps out, but that's the way that they do it. But great question. Jill from Kirkland, Washington. Thank you for calling in. All right, let's keep it rolling here.
Josh, good morning. It's P. Lola's mom from New Jersey. I may not even be the first person to ask this question today. Today is Thursday, and this morning on the Karen Reed trial, we saw one of the crime lab ladies who gave testimony yesterday. Today, when she was done giving testimony, she asked if she could clarify a mistake that she made yesterday during cross-examination. So my question is, if a witness needs to make any clarifications about the testimony they've given prior to them being done with their testimony and getting off of the stand, do they ask to see the prosecutor, in this case the Commonwealth, to discuss what the clarification would have needed to be made? Everybody was up in arms, and of course everybody ran for a sidebar, and then Bev came back and said no clarification, you're done, and she left the witness stand. But is that something that happens? I've never seen it before. Maybe you could tell us about a case that you know where a witness has said they want to add more or make corrections to their testimony. I appreciate it. I want to say hello to all of our trial family. It's a great chat, and anyone that doesn't join us daily should, because we have a lot of giggles, a lot of snarkiness, and we're making the best of a sad situation with Officer O'Keefe's death. So thanks so much.
Thank you so much, P. Lola's mom. Always good to hear from you from Mantoloking, New Jersey. Let's go ahead and throw you on the map there. And thank you for the shout out to our channel, Courtroom Confidential Live Trials. If you guys don't know, we are not streaming the trials live on the Courtroom Confidential main channel. And so we've created a brand new channel just for that. We've been streaming the Karen Reed trial every single day. on the Courtroom Confidential Live Trials channel. It's at CC Live Trials. And I pop in when I can, and we're in the chat, and it's a wonderful group of people. And if you want to watch the Karen Read trial with all of us here at the Courtroom Confidential Crew Nation, that's the place to go. So thank you, P. Lola's mom, for that shout out. This was an interesting one. This was again a little sprinkling of controversy in the Karen Read case, and I watched this happen. This was when Maureen Hartnett was testifying. There she is there. She was one of the forensic scientists on this case. She talked about the collection of glass from the damaged bumper, a collection of a hair, other little things. She was on cross-examination by Alessi, and at the end of her testimony, he had said no further questions. And then Hartnett says, quote, "I wanted to correct something from the record yesterday. I wasn't sure when was appropriate to do that." And you could hear all of the, like, you know, the record screech. All of the attorneys immediately tensed up because we hate when witnesses do that. What somebody's going off script. What is happening here? Somebody's gone rogue. And even the judge was like, and the judge clarified who asked the question that you need to clarify. And she said it was by Mr. Alessi. Then they asked for a sidebar, immediately went to their sidebar. And the judge came back out and said, questions from both sides are completed. We're going to go ahead and let you step down. I thought this was handled poorly. I am not one to jump on the bandwagon of hating on Cannoni, but I did not agree with this. I thought this was handled poorly because of the way it appears to the jurors. If I'm a juror, that's going to drive me nuts. That's going to really anger me, in fact. I'm going to sit there and go, wait a minute. This lady, you want me to be deciding this case, and this lady just told me that she got something wrong and wants to correct that. And you're just going to let her step down because all the questions are done? Well, what was it? What was it that needs correcting? She spoke about a lot of things that are important things that I might be basing my decision on. Let me hear the truth here. Really did not like the way. I feel like if the judge wasn't going to allow for further questioning, a better answer could have been given for that. Ladies and gentlemen of the jury, we've discussed it at sidebar. It is not an area important for blah, 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 but whatever it is, please disregard that comment, move on. Something, I don't know, anything would have been better than this to me. The other interesting thing about that is that I don't think it was something that she had shared with Brennan ahead of time, because I feel like if she had, Brennan would have stood up and said, I've got just one more question for this witness. You know, yesterday you said X, Y, and Z. Is there anything that you need to correct about that? This seemed to surprise everybody. And another interesting thing about that is when they went to sidebar, they didn't know what it was, but they all agreed upon the idea of not asking her. I think a better way of handling this would have been excuse the jury, take a moment, ask the witness to say outside of the jury's presence what it is that she wants to correct, and then allow both sides to handle that as they seem appropriate. Maybe Alessi would have said, great, I would love to have her answer that because I've got some follow-up. Or maybe Brennan would say, well, this is important stuff and we need to get into this. I just feel that the way that it was handled was probably the poorest way it could have been handled. Thank you again, though. Appreciate you, P. Lola's mom, for asking the question. All right, let's keep it moving here.
Hey, Josh and CC crew. This is Sarcasm from Fort Bragg, North Carolina. And yes, this is about Karen Read. I'm so sorry, y'all. Okay, so I'm pretty sure you've probably covered this in prior videos and conversations. But can someone please explain to me the process of charging someone with perjury? So many witnesses who literally are lying on the stand. Y'all, I just cannot with these people. I'm currently watching day 12 because I intentionally started late. But Yuri, Bukhenik, I don't know how to say his name. I'm struggling. I'm on the struggle bus. This is day 3 of me trying to watch day 12. Okay, that's how frustrated I am. But I need to know perjury, how that works, legal process, all of the things. Thanks so much.
Thank you so much, Sarcasm from Fort Bragg, North Carolina. Let's first of all put you on the map as a treat for calling in. Sarcasm, I feel like you might be a little frustrated by things that you have been witnessing take place in court, and you might be a little upset by how it's all getting played out. Great question. I think you reflect a lot of what people who have been watching this case might be feeling about it. Again, let's all be nice. Let's all virtually hug each other when we're talking about this case. But your question is about Yuri Bukhenik. And did he do enough on the stand to warrant perjury charges? Sorry to disappoint or sorry to please, whichever side you stand on that, but there are not going to be any perjury charges coming out of this testimony at all. Sorry. Again, I hate to sound so kind of like been there, done that, nonplussed about the whole thing, but we are way off from perjury. First of all, perjury, you have to be able to prove a knowingly false statement, not incorrect statement, not statement that you said one thing once and another thing another time, not statement based on ignorance, not statement based on misspeaking or misinterpretation or whatever it is. It is knowingly false. I know for a fact that the sky is blue, and I say under oath it's green. So you have to prove, first of all, what this person knew for a fact, and then prove that when they were saying such a thing about it, that they knew what they were saying was false for the purpose of saying a false thing, not because they were mistaken, not because they were misunderstanding your question, or that it leaves any kind of room for interpretation. So what you've got here instead is just what's called good old-fashioned cross-examination and impeachment. And anytime a person has been impeached by prior inconsistent statements, we don't charge them with perjury. It's prior inconsistent statements. You said X on this day, and now you're saying Y. Isn't that, in fact, something that we should call into question either your memory or veracity about that issue? But we're not going to bring perjury charges against that person. The only case I can think of where I even saw an attempt by the DA's office to bring perjury charges against a witness was when I worked on the Phil Spector case forever years ago. And that was when we had a defense expert who had submitted a report, testified that that was the only report they had ever done. And we actually had, because they mistakenly sent us another report where they had different opinions. We were able to cross-examine them with that, asked about perjury charges, and nobody filed anything. So there you go. But Sarcasm, love you and love the question, love the enthusiasm. Let's keep it going here.
Hey Josh, this is Willow from York, PA. I am calling in again. First of all, I want to say thank you so much for the shirt. So awesome, super awesome. I've been wearing it around. I love it so much. And I've been taking the past 2 weeks or so to think of a good question, and I'm going to try and keep it short and sweet for you this time. So in my classes currently, we're discussing character evidence versus habit evidence. you can't use character evidence. It's inadmissible, like to say he or she is kind, he or she is reliable. But habit evidence is admissible to say something like, oh, he or she goes to the store at 3 p.m. every single day, and that's part of their routine. That's their habit. So what I'm curious about, especially with the Sean Diddy Combs case and the testimony from Cassie regarding the abuse, what is considered then admissible under prior bad acts? Does there have to be a conviction in place for that to be admissible and brought up? Because you can't bring it up to say, oh, well, he abused me before, so obviously he's capable of doing this kind of thing. You can't use it as a character testimony. So I'm just curious what the difference is there. Thank you again for the awesome show. Thank you to Tiffany and Kay and everybody else that works on the production.
Thank you so much, Willow. What a nice question and compliments and everything else. And yes, shout out on our new t-shirts. This is one of them here. What is this color, Tiffany? What is this called? Dreamboat green or something? I don't know. They all got mint ice cream. I don't know. But I love these new colors that we have. And thank you, Willow, for the kind words about them. Willow from York, Pennsylvania. Appreciate you calling in. I love this question. I love this question because this is one of the areas of the law. Seafoam, says Tissos. If you want a seafoam green Courtroom Confidential shirt, you know where to go grab one at thecourtroomconfidential.com. What is the difference between character and habit evidence, and which is admissible and when, and what are prior bad acts? This is one of my favorite areas of criminal law because it is so incredibly powerful and so often misunderstood. But Willow, you actually did a really incredible job of explaining the differences. So yes, the first thing to understand is, I think a place to come from to fully understand is we do not put people on trial for who they are. Okay. So we don't want to try Diddy for being a very bad man. We don't want him to be convicted for crimes that he's charged with, racketeering and trafficking and everything else, because we just don't like him and he's a bad dude. And because he's a bad dude, he probably did these bad things. That's not the way we work. So if you understand that, then you might understand character evidence and habit evidence. Character is when we're saying this is who this person is. He is a violent person, or he is a mean person, or he's an honest person. We don't do that. We don't get into the character of the person. And it's not admissible if you're using it to show that they acted in accordance with that character. In other words, if you're saying he's a violent person, as a character trait, therefore he should be convicted of a violent crime. Not the way it works. Now let's talk about habit. And again, Willow, fantastic job. But habit is a specific, regular, consistent response that to a person has to a repeated situation is a good way to think about it. So as you gave some examples there, somebody who always checks their phone before they go to bed. We're not saying anything about their character. We're just saying they have the habit of checking their phone. Someone who always drives to work the same way. Again, we're not talking about their character. Someone who always calls their wife when they arrive at work. These are things that you can use because there's a certain inherent reliability to them. And so when they don't call their wife when they get to work, maybe you knew something was wrong. When you are trying to prove that they were at a certain location at a certain time, you can prove that by saying they always had the habit of driving this same way to work at the same time every day. Therefore, there's evidence they likely were that person in that blue car, whatever. And it's admissible to show that that person was acting in conformity of that habit. Okay. Here's where you might see the difference. Calling someone a bad driver when you're trying to convict them for a vehicle code violation, or saying that a person always speeds on the highway. If you're calling them a bad driver, you're trying to convict them for their character of being a bad driver. But if you're saying they always speed on the highway, you're showing that that's a habit, that when they're on the highway, they speed. And maybe they were speeding in this case, because they were driving on the highway. Anyhow, how does this all come back to Diddy and prior bad acts? First of all, prior bad acts are character evidence, but you're allowed to use it if you're trying to show something else other than character. Motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or accident. All of these are acceptable reasons to use character evidence. One of the most common is this idea of common plan or scheme, that this person, Diddy, is a person who likes to manipulate others in freak-offs. In those freak-offs, he would use GHB laced baby oil and on and on and on. And you can show a common plan or scheme. So if you're trying to say that we have evidence this took place on this date, you can use that as evidence that it likely took place on another date because it's common plan or scheme evidence, not just that he's a bad guy. Okay. I know this is still a little bit vague, but I hope you guys this is making it a little bit more clear. I had a case when I was in the DA's office. This person was dubbed the pink shoe robber. This person committed a string of armed robberies against GameStop locations, those game stores, always wearing a hoodie, always wearing a mask, and always with bright pink shoes. We had evidence that this person was arrested at one of these GameStops in a hoodie, wearing a mask with bright pink shoes. Then we presented evidence of a string of other robberies at different GameStops where a person was wearing a hoodie and a mask and bright pink shoes. Now, obviously, we didn't have eyewitnesses as to could identify that person because they're wearing a mask. But based upon this common plan or scam, we could use those prior bad acts to prove that they had committed all those acts. Because it wasn't being used to prove character. It was a prior bad act to prove common plan or scheme. Other thing to understand about these things is even though we call it prior bad act, it does not need to take place before the crime charged. It could even take place after. It's just prior to the trial and an uncharged crime. And that was part of your question is no, they don't have to be charged with it. It can be uncharged crimes. It can be uncharged conduct. It's prior bad acts, not prior bad crimes. Anyhow, I need some more coffee after all of that. I hope that helped, Willow. I hope I appreciate your question. I love that kind of stuff. All right. Coming to the home stretch here, guys. Let's get on to our next question. Hold on. What did I do? Oh, okay. Hold on. Everybody calm down.
Hi, my name is Jen. I'm calling from Ontario. I love your show. I like the way you break things down. And my question is regarding the Diddy circus going on. I was just wondering, he's literally being charged with RICO, which is Racketeering Influence Corruption Organization. And the a-hole, excuse my French, literally stares people down. And he's got a very intimidating stare. It's even been used in testimony. I think they're calling him shark eyes or dead eyes or anyway, it's obvious that he has an intimidating stare. Obvious that he's the vile, bottom-feeding, horrible individual I refer to as organism now because I don't even think of him as human. And why doesn't the judge step in and tell him to stop doing that? I'm sure that the juries don't like it either. And if it were your case, would you say something, Josh? Thank you. Bye for now.
Thank you, Jen. Jen, tell us how you really feel, though. Don't hold back. Tell us how you really feel about Sean Combs. Jen from Ontario, Canada, let's put you on the map. Appreciate it so much, and I appreciate your enthusiasm. Sean Combs, excellent question. Why doesn't the judge or somebody step in and stop all of this mad dogging, if you want to call it that? And first of all, again, a case we don't have cameras in courtroom, so this is the best we're going to do. Maybe that is a drawing of him mad dogging some witness, but they're saying that he's staring at people and being intimidating. Why doesn't the judge stop it? Should the DA stop it? Would I say anything about it if I were in court? Here's the answer. Yes, I would, just to make sure the jurors noticed it if they hadn't been, and then I would pray that he wouldn't stop, because this is absolute gold. I want them seeing this guy. Listen, you're trying to prove this guy is a horrible, manipulative, aggressive, violent person who gets his way all the time, always, and when he doesn't, he intimidates and harasses people. I want him doing that in court. That's gold. That's wonderful. So the only thing I might do is mention it so that the jurors make sure to notice it if they hadn't been. But I would really hope the judge wouldn't stop him from doing it, because I would want him to do it as much as possible. But great question, Jen. I appreciate you calling in and presenting the question and for representing Ontario, Canada. All right, let's keep it going.
Hi, Courtroom Confidential. Happy Sunday Fun Day. Unfortunately, it's been a crazy week with these trials. So, okay, so I'm a little worried and confused. And I guess I'm talking Diddy. Without getting into too much detail, obviously none of us want to do that. But how are they going to prove RICO? I mean, they have Cassie on the stand. What are they trying to get from Cassie that's going to further the RICO case? Because it feels like it's an emotional tug of war, and there's all this insanity and craziness. I can't even imagine being a juror. Okay, I'm going to be quiet. Thank you, Josh. I look forward to hearing your answer. Bye, everybody.
Thank you, Sonia. You never have to be quiet. That is Sonia, because I recognize you, and I know you're calling from Chicago, Illinois. So even though you tried to be sneaky, we're going to go ahead and call you out and put you on the map for Chicago, Illinois. A great question. And this is a question that a lot of people have been asking. In fact, I was doing a TV hit early this morning for the East Coast morning shows, and they asked about this in particular. How are we proving RICO here just through Cassie's testimony? And the idea is we're not. But the answer is that there's a lot of trials still to come. Yes, Songbits Laura says she was 8 months pregnant and strong and brave, and I completely agree. And the judge actually made them finish their testimony of her quickly because he didn't want her having a baby on the stand. So pretty incredible stuff. But did she move the needle on RICO? No, she really didn't. But this is witness number 3 in a very long trial. The prosecution has plenty of time to connect those dots. But really what we're talking about here is, in order to prove RICO, you essentially have to show a pattern of criminal activity. In other words, you can't bring RICO charges for one crime. So a pattern of ongoing criminal activity taking place within a criminal enterprise. So some sort of conspiracy or organization that doesn't necessarily need to know about each other. You know, the one hand doesn't need to directly be connected to the other, but you are joined in the common pursuit of a criminal enterprise, committing an ongoing pattern of criminal activity. Well, what Cassie is doing is showing some of that criminal activity. She is showing the end result of this criminal enterprise. Here's some of the crimes that were being committed by the Sean Combs criminal enterprise. And now it's up to the government to show that that enterprise existed, that he was at the top of the pyramid in that enterprise, and that these other people were acting in accordance with his wishes or directly based upon his orders. Yeah, Kraken Studio says, give them time to build the foundation. RICO is there. I'm sure that it is, mainly because I know the government, federal government, really doesn't blink without writing 15 different memos about it and running it all the way up the flagpole and back down. So I'm sure they've got the goods. It's just a matter of, can they prove it to the jury? But more than RICO, I think the bigger question here is the consent thing. Cassie I'm sure was incredibly reliable. Again, we don't have cameras in courtroom. Of course, Shy Gal, love to hear from you. Of course, we don't have cameras in courtroom to actually assess her testimony ourselves, but it sounds like it was very reliable and emotional and heart-wrenching, and she's pregnant and talking about these awful atrocities committed against her over years of abuse. But those text messages that the defense brought out are not a small problem. They talk about her actively participating in, encouraging, planning some of these freak-offs. I hate that we're using the word freak-offs. It keeps on coming up, but that's the term used. And her continuing to come back to this person who is allegedly abusing her. That's going to be an issue. And I think the prosecution is going to probably be more worried about proving to the jury, having them understand the cycle of abuse and why a victim would participate in that way and say those types of things in text messages than they are about the RICO at this point, to be quite honest, because that is something that jurors are going to be asking. Well, then why are you sending these text messages? Why are you planning these? Why are you saying you're looking forward to the next freak off if you're really doing it without all your consent? And was your lack of consent communicated to the defendant? Or was the only thing he was ever hearing is how much you look forward to the next freak off? Because that's important beyond anything else, that he knew there was no consent. So I'm not saying again that they haven't proven it. I'm just saying that's probably the thing that's more concerning to the prosecution at this point. But fantastic question, Sonia from Chicago, Illinois. All right. Are you a Sox fan or a Cubs fan? Curious. All right. All right, guys, here we go. It's our last question of the day. Who's going to bring us home?
Hey, Josh, it's Bone Girl. Was curious your thoughts on the Lewis twins, Qaadir and Naazir, that were found shot on the top of Bell Mountain in Georgia. They were found in early March by hikers. The initial ruling was a murder-suicide. The GBI is investigating it, but they haven't released whether they found a gun. The family says the twins wouldn't do this. They weren't hikers. They'd never been to Bell Mountain. And then more recently, a firefighter was arrested, alleged to have taken photos of the twins' bodies at the crime scene and posting it. So just curious, your thoughts on if it was a murder-suicide, why they wouldn't release that they found the gun, and also how much does the firefighter situation hurt the case? Thanks. Have a great day. Oh, and I'm pretty sure you know this, but I'm from Ohio. Talk to you later. Bye-bye.
Thank you so much, Farm Girl, calling from Ohio. Always great to hear from you. Big time supporter of ours, and I appreciate you always calling in. So let's put Ohio on the map. And a case I had not heard of. I'm surprised. Kaylin had actually heard of it. I had not heard of it. This is a really sad and bewildering case. These two young, good-looking gentlemen are twins by the name of Qaadir Lewis and Naazir Lewis. This is from out of Georgia. They were 19 years old. On March 8th, they were found at a location called Bell Mountain, which, by the way, is 90 miles north of Lawrenceville, where they were from. So they were 90 miles away from home. They were scheduled to fly to Boston and had gone to the airport, but apparently their ride share, Uber or Lyft or whatever it was, got them there late, and they missed their flight. And then for whatever reason, found themselves 90 miles away in Bell Mountain, Georgia. I am giving you the barest of facts that I have learned in the research that I have done, but believe me, I've got lots of questions myself. In any case, they are found shot to death, dead from gunshot wounds, both of them at this location. The Georgia Bureau of Investigation, the GBI, says that they're still waiting on the medical examiner's report, but that the preliminary conclusion is that this is a murder-suicide. So I don't know what evidence is going to come out of that ME report that would change their mind or confirm, but you make an excellent point, Farm Girl, in that if it was a murder-suicide and no one else was involved, we would expect a gun to be right there. And why haven't they released that information that they found the gun? The answer is, I don't know why. You would think that that would be something they would tell us immediately so that we all understood why these two handsome young men would do this. Their family is beside themselves, saying they've never been to Bell Mountain. They never have any reason to go up there. They never would do something like this. I mean, there's a lot of things. I will say in these cases that involve self-harm, it's never something that family members can really wrap their heads around. It is just such a tragic thing, and we never want to accept it. But in a case like this, it's got a lot of other bizarre surrounding circumstances. What were they doing 90 miles away? Why did they miss their flight? Why didn't they tell anyone they missed their flight? Why in the world your own brother? You know, I mean, just a bunch of unanswered questions. And then on top of this, and kind of unrelated, there was a firefighter who arrived on the scene that took photos of them and put them out, released them publicly somehow. That person has been charged with a misdemeanor for obstruction for taking those photos, but that's not going to affect the investigation of this case, I think, at all. It's just a really bizarre case. I will say this, that sometimes cases are just bizarre, and sometimes there are unanswered questions, and unanswered questions don't always necessarily mean conspiracy. But this is one of those cases that you hope that they give us a little bit more, to at least give some more understanding to the families involved. But really interesting. Thank you so much, Farm Girl, for bringing that up. I had not heard of that case. All right. What do you guys think? We talked about Sean Combs, and we talked about Karen Reed, and we talked a little bit about Kohberger, and we talked more Karen Reed, and we had, what was this case that I had never heard of? Well, we talked a little bit about Aliza Sherman. Again, huge thanks to Gisela and the Grizzly True Crime Nation for participating in that. We got to see Nancy Grace call me a pervert. We got, what was that? Oh, what was that case? Oh yeah. Betty Williams and Mack Herring. Crazy case. Thank you, Alicia K. Mayo, for bringing up that one. Really great show today. You guys are all fantastic. Let me get you some quick announcements and then let you move on with your Sunday. First of all, yes, thank you all to the super chats and everybody who gifted and all your support. You're all fantastic. And for everybody who's been in the chat all along the way. First of all, yesterday, we released our weekly roundup. If you haven't seen it, please check it out. We talked about Menendez brothers and Diddy and Kohberger and a bunch of other cases. By the way, did you guys know that the Menendez brothers got resentenced and they might be out of prison this year? Crazy. All this week, check out Courtroom Confidential live trials. If you want to be and sit at the cool kids table and watch the Karen Reed case and chat with everybody that you love from the CC Nation, CC crew, please check out Courtroom Confidential live trials, where we're streaming the Karen Reed trial. And we got to pick our next trial coming up here soon. Monday, we have the latest in our conversation series. If you haven't heard this announcement already, we sat down with Alexis Linkletter. We had a fascinating conversation. She is the host of two podcasts. One is called Unraveled. The other is called The First Degree. She's got a very interesting background. And we had a really great conversation. That will be released this Monday, tomorrow at 5 p.m. Pacific, 8 p.m. Eastern. And then, as always, this Wednesday, we will have our Wednesday Night Live, and we do not have a guest confirmed just yet. So it's going to be determined on that. membership. Hold on. Everybody calm down. If you want to know where to become a member for Courtroom Confidential, then please head over to thecourtroomconfidential.com and click on become a member. And the reason why you might want to do this soon is we have our next members only live coming up next week. We're going to pick a day. I think we're trying to decide between a day at the end of the week. But that is where you get all those good stories and where you get the behind the scenes stuff and where I forced Kaylin and Tiffany to get on camera. They don't know that yet, but it's happening again, this members only live. So please check out our membership program. You guys won't regret it. And the courtroomconfidential.com page is also where you can find our shop. So if you want to see the new merch that we have, including this Seafoam t-shirt, this is where you can go. And it is also the place where you can click on send us a message and start recording your messages that we will answer on the next Sunday Funday next week. Please do that. We love the questions. We love all of you. Thank you, Carol Pack, for becoming a YouTube member. Thank you so much to Afton and Shy Gal for being our mods, and to Kaylin and Tiffany for behind the scenes and everything you do. And thank you guys all for being here. Have a wonderful rest of your Sunday. And we'll be talking to you guys all soon. Take care, everybody. Bye-bye.